Hi and welcome to Hull and Hull TV. I'm Dana O'Brien and I'm joined by Ian Hull and Suzana Popovic-Montag, partners at Hull and Hull LLP, an innovative law firm that practices exclusively in estate, trust, and capacity litigation. Here at Hull and Hull TV, we're exploring the issues around estate planning that affect you. For many of us, writing a will is not a priority. In fact, about half of Canadians do not have a will, but there are a lot of good reasons why they should. Ian, let's start with you. What is a will and why should we have one?
Well, the will is a written document that is the roadmap for your executor in terms of how your assets are going to be distributed, when they're going to be distributed, and on what basis they're going to be distributed. And it's a vital document in all of our estate plans because it is the last standing contract, so to speak, to deliver to those that are going to look after your affairs. And it needs to be clear and concise as it can be, and it has to be something that is your wishes.
What's the criteria for a will? Suzana, could I scribble my wishes on a napkin, for example? Would that be valid?
Well, the formalities of a valid will are going to depend upon the nature of the will that you're creating, whether it's, for instance, a typewritten one, which is known as a formal will, or a handwritten one, which is known as a holograph will. In either case, of course, both wills have to be in writing. With a holograph will, as long as it's in your own handwriting and it's signed at the very end of it, it'll be a valid will. With a more formal will, you will require, normally, the involvement of a lawyer, which will require that the will also be, again, in writing, signed by the testator, and witnessed by two witnesses, which is a little bit different from the holograph will. So in answer to your question, it may be that that scribble on a napkin, if it's signed and completely in your own handwriting, is a valid will. Not a perfect one, but definitely could be one.
So in terms of the place to start, Ian, what would be your advice? See a lawyer? What's the first place to start in terms of a will?
Well, I think it's best for you to sit down and create your own priority list. Sometimes it's very simple. Your children and a spouse, you give it all to your spouse and then to the children. There's not a lot of detail and not a lot of analyzing that you're going to do for your estate plan. But most people, as they move through life, it gets a little more complicated. And the allocation of assets and where they want to go and when they want to go. Do you want to set up a trust? Do you want it to go outright to your kids? Do you want the cottage to be dealt with in a special way? All of those things that all of us see changing over our lives in terms of priorities and in terms of allocation all need to be sat down and created in your own wish list. Then take that information and go see a lawyer to start the process of the actual drafting of the contract or the document itself.
Suzana, what are some of the other types of wills, and do you need a lawyer?
Well, there certainly are different types of wills, and the reality is, no, you don't always need a lawyer. There are formal wills or holograph wills, and nowadays we see a lot of the do-it-yourself will kits as well. In my experience, though, when you're dealing with these situations, there is a potential for a legal minefield. And so when you don't involve a lawyer, you may be doing so at your own peril.
And speaking of peril, what if you die without a will, Ian?
Well, throughout Canada, the rules are very clear, and essentially the government steps in and tells us how your estate will be distributed. And it will have a formula that imposes the distribution, and it will not have the detail of how, when, and the timing set out because it's all based on the local provincial statutes. So in short, government steps in. If you want to leave it to them, go for it.
Ian and Suzana, thank you. And thanks for joining us on Hull and Hull TV.